Judge in San Francisco recently ruled that the mass firings of probationary employees by the Trump administration are likely unlawful. U.S. District Judge William Alsup's decision grants temporary relief to a coalition of labor unions and organizations that filed suit against what they describe as a systematic dismantling of the federal workforce. The ruling specifies that the Office of Personnel Management, or OPM, does not possess the authority to order these firings across various federal agencies, including the Department of Defense. Judge Alsup stated emphatically that OPM does not have any authority whatsoever, under any statute in the history of the universe, to hire or fire employees outside its jurisdiction. This lawsuit is part of a broader legal challenge to efforts aimed at significantly reducing the size of the federal workforce, which President Trump has characterized as bloated and inefficient. This issue so relevant? Well, there are approximately 200,000 probationary workers within federal agencies, those who have less than a year on the job, and many provide essential services ranging from veterans care to fire prevention. Plaintiffs argue that these firings were based on misleading claims about employee performance. The government's lawyers contend that OPM merely requested agencies to assess whether probationary employees were suitable for continued employment without issuing direct firing orders. Opinions vary widely on this situation. Noted by Janie Har writing for several outlets including AP News and ABC7, attorneys for labor unions see this ruling as a crucial initial victory, while emphasizing ongoing legal battles ahead. Annie L. Leonard, an attorney representing this coalition, remarked post-hearing that what it means in practical effects is that agencies should hear the court's warning. Conversely, government officials assert that probationary employees do not have guaranteed employment and should only be retained if deemed high-performing and mission-critical. Looking ahead, we can expect significant impacts from this ruling on both affected workers and on how agencies approach hiring practices moving forward. Upheld during future hearings, an evidentiary session set for March 13, it could lead to reinstatement attempts for some fired workers, while potentially reshaping policies regarding civil service protections more broadly. Historically speaking, mass terminations within government often evoke discussions reminiscent of past workforce reductions seen under various administrations aiming to streamline operations or reduce costs, but seldom has it attracted such widespread litigation. Right off the bat, it's important to recognize how recent legal trends may shape public sector employment standards in years to come. And considering the bigger picture here, what people may overlook is how economic pressures influence administrative decisions like these firings, while also provoking backlash through judicial channels aimed at protecting workers' rights. There's also an underlying tension between governmental efficiency initiatives versus union protections, a dynamic continually evolving alongside changing political landscapes. In conclusion, Alsup's ruling offers immediate reprieve for many impacted by these actions and challenges, perceived overreach by executive agencies. Gore's ongoing tensions between aims for efficiency and governance and protection against wrongful termination, all critical components in safeguarding rights within our public sector jobs. Continue monitoring developments around this case, as well as others tied into similar themes surrounding labor rights. Amidst governmental reforms, stay tuned for updates.